Let's Talk, presented by Anna Glavinsky.
So around the world, ordinary people are turning to the courts. They're looking for legal action and seeking justice, but not for themselves, but for wrongs done to the environment. Now, in order to do this, you need a barrister going to those courts with you and actually advocating for those without a voice, the forests, the rivers and endangered species. Now, that's where Mónica Feria Tinta comes in. She is said barrister for exactly that type of thing. And she's written a book called A Barrister for the Earth. It sounds extremely powerful. Delighted to be joined by her on the line right now. Good morning, Mónica. How are you?
Good morning. I'm very well.
Thank you. Thank you for joining us, and thank you for the wait there. So your book, A Barrister for the Earth, I take it it's been written on the back of you fighting on the front line for the environment, things. Well, I wanted to say people without a voice, but that's not the right word. Things without a voice, causes without a voice. Where did your experience in this side of the law begin?
Well, I specialized in international law, including in international environmental law. When I started my career at the bar, I started practicing also in environmental law in England and Wales. So this is already since 2014. And things have moved quite far from that year because the environmental crisis, the climate crisis, has shown us how important and relevant are all these cases that now we are seeing in courts around the world.
And was there any case that particularly inspired you or catapulted you particularly in this direction of the environment? How did you start to think that this was an area that you wanted to represent, especially as, the people that you're representing and the things that you're representing can't come to you and ask for it. You almost have to find the causes yourself.
To be honest, when I was a pupil, I was involved in one of the longest cases in court. It was 5 months in court, in English courts, concerning the construction of an oil pipeline and people in Colombia and alleged environmental damage. Why? Because there's a lot of companies that are incorporated in Europe, but their actions take place somewhere else. So European courts in some jurisdictions can have jurisdiction to hear such cases. And to me, that really blew my mind because I thought, wow, there is a possibility of addressing environmental wrongs that are happening in various parts of the world, even if you are based here in England. So that was the first huge experience, let's say, with a really a mass claim. It was a group litigation case, which opened my eyes to that. And when we had the Paris Agreement, posed the question that we had then obligations that were acknowledged by states, but not enforcement mechanism. So I was contacted to provide advice on whether there was a way to enforce the Paris mechanism via other older systems, let's say, that were already in place, like human rights or the Tribunal for the Law of the Sea, etc. So my answer to that was in the positive. So I believe that other legal frameworks that were pre-Paris Agreement were capable of, with the new outlook of the Paris Agreement, interpret all regimes, all treaties in a different way. And that's exactly what happened. So from one point onwards, I got really deep into arguing this, including the first international case that held a state accountable for lack of climate action, the Torres Strait Islanders case, before the Human Rights Committee in Geneva, which started a revolution, really, when it came to climate law. So addressing biodiversity laws and the affectations that all of this caused on people. So I guess it all started really from that. And when working in these cases that, of course, involve people, I realized that ultimately it was about our relationship with the environment and how the anthropocentric perspective was limited, and we needed to move onto a more ecocentric perspective and recognize that the lakes and the seas and the mountains and the glaciers that were melting and the natural world really was valuable, had an intrinsic value and not, was just something to exploit. And also that we were talking about living entities. So, then it came the case of Ecuador, the Constitutional Court. I was contacted to provide an amicus curiae. So there are guardians, Anna. So it's not that there is no possibility to learn about this. The guardians around a living entity usually want to protect it. And this is how I get contacted to act on these cases.
Okay, absolutely understood. And actually, you've really built up a picture already in answering these questions so far. But I just wondered if you could sort of fully flesh out for us, what does it truly mean in practice to give legal rights to the earth? If you could sort of break that down to people who don't know the ins and outs of law.
Yes. So the best example that we have currently is the example of the Constitution of Ecuador.
Okay.
So Ecuador in 2008 abandoned an anthropocentric perspective, which is just to give rights to human beings and other maybe limited abstract entities such as corporations, to give them rights, civil rights, the rights, substantive rights, and the right to appear in court in one's own name. So in the case of Ecuador, the Ecuadorian constitution acknowledged rights to nature. What does that mean? For example, the right to exist, to persist, to have respected the processes that are intrinsic to that particular living entity. So, in the case of a particular forest, let's say, it will be the entire ecosystem that is protected, and it will have the species there will have the right to exist. So, other articles connected to this inherent right to exist will be the protection of a species and the prohibition of extinction of a species. So very few legal systems have that, not because it is a thing, but because it has the same, if you went, a status as it could be the life of a human being. And this is the distinction with, maybe protecting a pet because, you love the pet and you don't want it to be harmed. So this is a taking nature to a different level and accepting that nature is alive and that the processes around nature are so important to, let's say, a society, that therefore you give the highest protection you can, which is via the constitution in a country. So Ecuador had these norms already since 2008, but there was very little jurisprudence that could really explain what did that entail. And Los Cedros case, the case in which I acted, was the first time where the Constitutional Court of Ecuador tested these provisions on a particular case. And this was a forest that was threatened with a mining operation. And it is there where the judges had to construe, what does that mean? So what trumps what? And certainly they decided in favor of the forest, that the life of the forest, the right to exist of that forest, because of the endemic species, because of the role that this cloud forest has in the climate processes in the world, because of the variety of species that would otherwise disappear because of the work of a gold mine there. Because of all of this, it couldn't take place. So the rights of nature had to trump any other attempt to destroy this world. And I thought that was a very tangible demonstration of how that operated in principle. So here in the UK, for example, we are all watching that because of the degradation that we are witnessing with rivers. Rivers are legal entities that have also been worthwhile at the center of this movement on the rise of nature. Rivers being acknowledged as living entities, water as being alive, and not just as mere, dead kind of things. And there has been already around the world courts, like in Colombia or in Peru, in India, in New Zealand, in Canada, where rivers have been acknowledged to be alive and to be a legal person. And in Spain, we have had also the example of the Mar Menor.
So you're obviously very passionate about this. This is something that you believe in and care about sort of morally, as well as it sort of just being a job. But you have to go up against states, whole governments, multinational powers. You're going up against big bodies. And I think it's completely fair to say that we know that climate change is happening, but these big bodies are in general very slow to act upon it. How much responsibility do you feel that the law industry and that lawyers have in tackling these big bodies and getting things moving faster?
Well, lawyers have a very important role in all of these. If you go back to history, you will see that law has constantly changed, responding to societal needs and responding to our understanding also of what is fundamental for humanity, for society, moving forward for the future. So I think we have arrived to a human rights developed in a way on the understanding that it was critical to protect human rights, human life, after the wars that show us the level of atrocities we were capable of. And this is how we had all these frameworks that today we have. Environmental law has developed a little bit slower and later, but we are understanding at this critical point how crucial it is environmental law, how crucial it is the natural world to even our own survival because of the crisis we are witnessing right now, which is extremely serious. So who are the architects of the new, if you want, laws, and who are the architects of the developments that will take place? Well, lawyers have a very key role to play there, either working in government or as advisors or as litigants. And, well, I am an advocate who appears in courts, so I see my role providing services to my clients, but also clarifying the law for courts, contributing to lawmaking in that way. So this moment, it is defining for humanity. And it's not just on the climate issue, it's on biodiversity. The crisis is very far-reaching. And I believe that this is the constitutional moment where humanity will decide very important aspects of the future, including how do we relate to nature? How do we reconceive our relationship with nature, particularly in a context where technology is advancing extremely fast? But at this point in time, the way we have related to nature, exploiting it, extracting, and just looking at it as a thing to exploit, it has failed. And that's why we are in this crisis. And as you pointed out, it's quite dramatic how one of the cases I just mentioned, Torres Strait, was about Ireland's sinking. So the UN has recognized that what has moved the agenda when it came to climate was not the COPs, was litigation. So was the average ordinary person going to court and claiming we need to address this. And so this is what has happened, and we will continue doing that because it is necessary. But it's also necessary a change in our mindsets and recognizing the extreme value that nature has and starting acting swiftly doing that. And this is what a lot of communities are doing in the UK now with the protection of rivers. Anna, is massive. I have just been contacted by councillors in Hampshire, here in the UK. I advised before to give protection to a river in Lewis, the River Ouse. The River Thames is also having guardians that want to protect it. And there are many other councils that are working on that with the River Wye, up there with the River Severn. So the crisis pushes communities to act, and communities need lawyers. So that's what I see the role of lawyers being in the next years.
Absolutely. It's interesting. It certainly is, and important, and responsibility, no doubt about it. But what about hopeful? How optimistic is your book, and how optimistic are you?
Well, the book was written, having had some experience watching devastating wrongs, but at the same time, I discovered that we were so powerful and that it was possible to be able to make an impact, to contribute to change. I think that really encouraged me, and I wanted to share that with other people because as an individual person, I managed to see my own power as an advocate in bringing about change. We had, just to give an example, when some years back, 6 years back, I was arguing that the meaning of pollution under the Convention on the Law of the Sea meant or encompassed as well GHG emissions. And at the time, perhaps just one professor agreed and nobody else. But we started advising states. Eventually, the case for an advisory opinion reached the International Tribunal for the Law of the Sea, which we were trying to obtain. And last year, the tribunal delivered a groundbreaking decision where it acknowledged, you see, nowhere in that treaty, the Treaty for the Law of the Sea, mentions the word climate. But the tribunal interpreted its own convention in light of our new challenges. And what happened was that we won. Now there is a completely new understanding of obligations of states in relation to the sea. 70% of the earth is seas, oceans. So this is a very important decision. So I give that example to show you that why action is important and why I am optimistic. And I think that the book was part of showing that to people, so to empower people, because it depends on all of us.
Oh, fantastic. Well, thank you so much for joining us today. And also thank you for putting pen to paper and getting this book out, getting your thoughts and experiences out. And also thank you for all the work that you do. Really great to speak to you today, Mónica. And I hope you have your lovely afternoon, rest of your day.
Thank you for having me. And I hope that the audience manages to enjoy the book.
Absolutely. I'm sure they will. The book itself is called A Barrister for the Earth. You can find it on Amazon or the Talk Radio Europe bookshop, and it's by Mónica Feria Tinta.